Good afternoon. Welcome to Fasken's 2022 mining series, actually our 12th consecutive series. I am Frank Mariage, and I'm a member of our global mining group and a partner in the Montreal office in Fasken. Today's session is our 11th of 15 sessions, which continue until Wednesday, March 9th. Please refer to the slide on your screen for some housekeeping items. And we do hope that you will complete the survey by clicking on the tab underneath the video window to complete the survey. Now I turn it over to my colleague, Kay Alderon, the moderator for Indigenous Law Update, and who will introduce today's panel. Kay, over to you.
Thank you so much, Frank, and thanks to all of you for taking the time to join us today. As Frank indicated, my name is Kai Alderson. I'm a partner in the Energy and Natural Resources Group in Fasken's Vancouver office, and most of my practice revolves around helping mining and other natural resource companies build stronger relationships with the Indigenous communities in the areas that they operate. I've been at this for a while now, and really over the course of my practice in this area of law, change has been the only constant. But recently, it feels like the pace of change in the area of Aboriginal law is, if anything, accelerating. So if you're finding it hard to keep track, you're not alone and you've come to the right place. We've got a great panel to walk you through some of the most recent developments in Aboriginal law in Canada. Before we get started, I want to recognize that while we are all coming together in one place virtually, each of us is located physically in a different place. And for those of us joining this webinar from within Canada, let's just take a minute to acknowledge the ancestral territories of the respective First Nations, Métis, and Inuit peoples from whose lands we join the webinar today. So let's get into it. We've assembled a great panel of speakers for you, and I'm going to introduce them in sequence and maybe give a little wave as I introduce you. First is Dani Bryant, a partner in our Vancouver office. She is a litigation and dispute resolution lawyer focusing on Indigenous, environmental, and regulatory law. In addition to appearing in court, Dani provides strategic advice to clients on major projects and assists clients with matters relating to consultation with Indigenous groups and negotiating agreements with Indigenous communities. Emilie Bundock is a partner in our Montreal office and is a member of the firm's energy and climate, mining, and Indigenous law practice groups. Her practice focuses primarily on energy and natural resources development projects, where she advises clients on all sorts of matters relating to Indigenous law, from consultation to drafting and negotiating agreements. Sophie Langlois is an associate in our Toronto office. She has a broad-based corporate and transactional practice, but has a particular focus on engagement with Indigenous communities, as well as permitting ESG and sustainability in the mining sector. Last but not least, Zach Romano is an associate in our Vancouver office and is active in Fasken's global mining and Indigenous law practice groups. He advises clients on a range of commercial, transactional, and regulatory matters involving Indigenous communities. Zach is Métis and a descendant of the historic Métis community at Lac Sainte Anne, Alberta. I can't think of a better panel to help you work through that changing landscape of Aboriginal law in Canada. You folks are in for a treat. So let's move on. If we can advance the slide to talk a little bit about how we're structuring the session. When we were putting the session together, we quickly realized that we couldn't just give you an update on recent court decisions, because important as those are, really doesn't tell the whole story. So we decided to split our session into two distinct segments. In the first segment, Dani Bryant will be providing an overview of recent developments in the case law relating to Aboriginal law. And then Emilie, Sophie, and Zach will be joining me for a more interactive panel discussion to cover some other key trends that are impacting relations between Indigenous communities and mining companies in Canada. And then we're going to end with a question period. We've already got some very substantive questions in advance from participants, and we're looking forward to other questions as we proceed. And so I'm looking forward to that as well. But first, we'll start with our case law update. Dani, over to you.
Hi, everyone. For the purposes of this presentation, I have been tasked with kind of doing a bit of a case overview of some of the recent cases of interest from the courts. There's been a lot that's gone on in the past few years, developing the area of law. And so there's 4 key cases that I thought that I would try to talk about today. Next slide, please. So these are just from the past couple of years, and I'll try and go through them quickly, but give you a sense of what each of them is about. And I'll start with the Thomas and Saikus case, which is the most recent case. It came out earlier this year. Next slide, please. So this case deals with the Kenny Dam, which in the 1950s, the government authorized, in BC, authorized Rio Tinto to build the Kenny Dam, which created the Nechako Reservoir to provide hydropower for Rio Tinto's aluminum smelter. And the majority of water discharged from the reservoir is discharged to the west into the Camano River and the Camano generating station, with the rest discharged into lakes and tributaries to the east that flow into the Nechako River. And that Nechako River joins with the Fraser River at around Prince George. And the flow of water in the Nechako was substantially changed by the creation of the dam. So in this case, the 2 plaintiff First Nations, who are distinct Takel or Carrier Indigenous groups, the Saikus First Nation has a reserve located on the Nechako River, and the Salatin First Nation Reserve is located at the west end of Fraser Lake, which is part of the Nechako watershed as well. And both First Nations fish for sustenance in the Nechako watershed. And they claimed an Aboriginal right to fish in the Nechako watershed. They asserted Aboriginal title to the lands adjacent to and the beds of the lakes and rivers in which they have traditionally fished. And they invoked their Aboriginal rights as the basis for common law tort claims against Rio Tinto in Nuisance for breach of riparian rights. In essence, they claim that the changes in the river flow interfere with their Aboriginal fishing rights because it has impacted fish stocks, including salmon and sturgeon. And they sought, should I say, injunctive relief to compel Rio Tinto and the government to restore a more natural flow regime to the Nechako in order to prevent further impacts to fish and to ultimately restore the abundance of sturgeon and salmon in the river. And so this, in essence, it's a private nuisance claim, and private nuisance claims as a background are based on interference with property rights. Nuisance also focuses on the harm suffered by the plaintiff rather than the fault or blameworthiness of the tortfeasor. And the plaintiff must show a causal connection between the activities of the defendant and the harm it suffers. So the test is whether the interference with use and enjoyment was substantial and unreasonable. However, the substantial element of that test just means non-trivial. It's quite a low threshold. And unreasonableness is focused on the harm suffered rather than the actual conduct of the defendant. And the unreasonableness is assessed by balancing the harm to the plaintiff and the utility of the defendant's conduct. So that's just kind of a background of the tort that was claimed. This is the first case where it has been based in an Aboriginal right. The claim has been based in an Aboriginal right instead of ownership or possession of the land itself. Next slide, please. So the trial took almost 2 years and lasted 190 days. And the court found that the plaintiffs have a constitutionally recognized Aboriginal right to fish in the Nechako watershed. The plaintiffs' interest in and occupancy of their reserve was sufficient to found an action in private nuisance arising from substantial and unreasonable interference with their use and enjoyment of the reserve land. And the plaintiff's Aboriginal right to fish was also sufficient to found an action in nuisance in the circumstances. The court also found that the Kenny Dam and reservoir, by the changes that were caused to the water flows in the Nechako, was a non-insignificant contributory cause to the decline of both sturgeon and salmon in the Nechako, and the reduction of sturgeon and sockeye have had very profound impacts upon the plaintiff First Nation. So in the circumstances, Rio Tinto would have been found liable for the tort of private nuisance if not for the defense of statutory authority. And that defense did apply in that circumstance. And so the reason that defense applied was because the dam was constructed and operated as approved by government, and that Rio Tinto had strictly complied with its regulatory requirements. And so in that case, the Rio Tinto's actions were the inevitable result of the authorizations that were granted to it. So because of that, it was not found liable for private nuisance. Now, on that defense of statutory authority, the onus of proving it is on the defendant. The onus of proving that the actions of the defendant or the harm caused is the inevitable result is on the defendant. In that case, the plaintiff First Nations, they claimed for an injunction and seeking to either end the dam, to remove the dam, or to return water levels back to higher levels in order to improve the fish stock. But the claim for the injunction was dismissed because the defense of statutory authority applied. However, the court did make declarations of Aboriginal rights to fish, and that as an incident of the honor of the Crown, both levels of government have an obligation to protect that right. Next slide. The plaintiffs are appealing the decision. The decision represents an expansion of the potential liability faced by proponents, in that it's the first decision to hold that a claim for a common law tort can be actionable based on impacts to Aboriginal rights. The decision also reinforces the wisdom of trying to achieve impact benefit agreements or project agreements with Indigenous groups, and it signals the importance of operating within the scope of the government approvals that you have. Next slide, please. So next, I'm going to briefly talk about the Yahi decision, which is a recent decision from the BC Supreme Court. In that, up until this case, infringement of Aboriginal and treaty rights has focused on individual projects or other regulatory authorizations or specific provisions in statutes or regulations. Here, however, Blueberry River First Nations alleged that it was not one single impact from one project or a regulation that infringed their rights, but rather of provincially authorized activities, including oil and gas, forestry, agriculture, hydroelectric development, all of those activities cumulatively within their territory. And they claimed that the province's approval of such developments on an approval by approval basis failed to take into account the cumulative impact of prior approvals in the area, that the province's ways of assessing project approvals didn't adequately consider cumulative impacts as well as impacts to their treaty rights. So they sought a permanent injunction to restrain the province from undertaking, causing, or permitting activities that would further the infringement of their rights. Next slide, please. So the court found that the province took up lands for industrial development to the extent that there was no longer sufficient and appropriate lands in Blueberry's territory to meaningfully exercise their treaty rights to hunt, fish, and trap. And so by causing or permitting the cumulative impact of industrial development, the province breached its treaty obligations, which include the obligation to act with the honor of the Crown and their fiduciary duties towards Blueberry River. The court found that the province's discretionary decision-making processes did not adequately consider cumulative effects or the impacts on Blueberry's treaty rights. And the court ordered the province may not continue to authorize activities that breach the treaty or its treaty obligations, and that the parties must negotiate mechanisms to assess and manage the cumulative impact on Blueberry's treaty rights. So just for context, the province did not advance a justification defense in that claim, and they did not seek to bifurcate the proceeding or sever the question of justification for a later hearing. So the court concluded, based on the evidence led by the province, that the infringements were not justified. The province did not appeal the decision either. Next slide, please. So since the decision, the province and Blueberry River have been in negotiation. In October, they announced that they had reached an initial agreement which established a fund to allow Blueberry to undertake restoration activities in the claim area and to protect Blueberry's way of life, to protect cultural areas, trap lines, cabins, and trails. And according to that announcement, they advised that they are working on an interim approach to reviewing projects, and that once that interim approach is in place, that they will move on to a longer-term approach. This decision is a BC Supreme Court decision, so has limited applicability in other provinces, but it is the first example of a successful Aboriginal rights claim based on cumulative impact. It is, however, not the only claim that has been brought based on cumulative impact. There are other cases working their way through the system. One of those cases, notably, is a case brought by the Beaver Lake Cree Nation in Treaty 6 territory in Alberta. As in the Yahi case, they allege a systemic problem, claiming that the Crown failed to properly manage the taking up of land in their treaty, under the treaty. And the original claim was filed in 2008. Since then, Blueberry River has spent over $3 million in legal fees and pays approximately $25,000 in legal fees a month. And the trial has been scheduled until 2024. So as part of that proceeding, there's actually an application that the nation has brought for advance costs, which would be to have the province and Canada pay their legal fees in advance of the hearing of the trial, in advance of the trial. And this application has been working its way up through the courts and is now been heard by the Supreme Court of Canada. So a decision is expected sometime in the new year, as the hearing was at the end of last year. Next slide, please. So the next case, Ermineskin Cree Nation, deals with the duty to consult. So Ermineskin is a signatory to Treaty 6 in Alberta. And in 2013 and 2019, the nation entered into benefit agreements with Coalspur, a proponent regarding potential impacts of the Vista Coal project on Ermineskin's Aboriginal rights. And these impact benefit agreements, they were intended to compensate Ermineskin for potential impacts caused by natural resource development on the ability of Ermineskin members to exercise their Aboriginal rights. So the agreement specifically contemplated potential impacts to their rights and the provision of benefits to compensate for that. And the decision under review relates to a decision of under the Impact Assessment Act, which applies to activities that are listed in the regulations or which are designated by the minister on the basis that the physical activity may cause adverse effects within federal jurisdiction, or adverse direct or incidental effects, or based on public concerns regarding those effects warranting the designation. And once a project is designated under the Impact Assessment Act, the proponent may not carry out the activities that may have an impact on the federal jurisdiction until the federal assessment process has been completed. So it has the potential to significantly delay a project. So in December 2019, the Minister of Environment and Climate Change decided that the project did not warrant designation under the Impact Assessment Act. This was consistent with advice from the Impact Assessment Agency, which consulted with the 31 Indigenous nations in the region, including Ermineskin. However, in July 2020, the minister reversed course and decided to designate the project for a federal impact assessment. And this change in course was the result of an application brought by 2 neighboring First Nations with public interest group support for the minister to issue a designation order. And the 2 First Nations who sought the designation order were given the opportunity to reply to Coalspur's responding submissions, whereas Ermineskin, on the other hand, was not given notice of the decision or the opportunity to participate in the designation order decision. Next slide, please. So the court determined, the court quashed the designation because the Crown must consult with Indigenous groups that hold economic interests derived from or closely related to their Aboriginal rights, where those interests may be impacted by a decision. Since Ermineskin's economic interests could be adversely impacted by the minister's decision to subject the project to federal impact assessment, which included could be impacted by being delayed or having the project not potentially be approved, they should have been consulted. The fact that certain benefits had not yet materialized under the impact benefit agreement did not negate the Crown's duty to consult. And the consultation process was thus flawed because it denied Ermineskin the right to participate and only considered the perspectives of the nations who were seeking the designation order. In that case, Coalspur also filed a judicial review, which Justice Brown found moot in light of the decision based on this judicial review. Next slide, please. So the decision really means that Indigenous groups are entitled to be consulted when the Crown may impact their economic interests obtained through project agreements. And such impacts could be a delay in obtaining economic benefit or other type of impact. And the decision again highlights another benefit for both proponents and Indigenous groups for entering into project agreements. Next slide, please. So the last case that I'm going to discuss is the Desoto Case. And this case deals with cross-border rights of Indigenous peoples located outside of Canada. The Saikus people traditionally occupied land in what is now Washington State and British Columbia. And until around 1870, they continued their activities in the northern portion of the territory, which is located in Canada. And in the course of time, a number of factors caused the people to move to the United States. Until 1930, members of the Lakes tribe continued to hunt in British Columbia, despite living in Washington State. And then after 1930, despite periods where no hunting took place, the Lakes tribe continued to have a connection to the land where their ancestors hunted in British Columbia. Additionally, the last member of the Canadian group of Saikus people, known as the Arrow Lake Band, died in 1956, and the federal government declared the band extinct for the purposes of the Indian Act. So this case centers around events that took place in 2010, wherein Richard Desoto shot and killed an elk in southern British Columbia without a hunting license. Mr. Desoto lived in Washington State. He's a member of the American Lakes Tribe of the Confederated Tribes of the Colville Reserve, and he is not a resident or citizen of Canada. So the Crown charged Mr. Desoto with hunting without a license and hunting big game while not being a BC resident, contrary to the Wildlife Act. At trial, Mr. Desoto claimed an Aboriginal right to hunt for food, ceremonial, and social purposes under Section 35 of the Constitution Act, as he was hunting in the traditional territory of his ancestors, the Saikus people. Next slide, please. And so as the decision determined that Section 35 of the Constitution Act affirms Aboriginal treaty rights of Aboriginal peoples of Canada. What does Aboriginal peoples of Canada mean? The Supreme Court held that the expression Aboriginal peoples of Canada means the modern-day successors of Aboriginal societies that occupied Canadian territory at the time of European contact. And this may include Aboriginal groups that are now outside of Canada, including for reasons such as where they moved later on or were forced to move elsewhere, or where international boundaries were imposed on them. And the Aboriginal rights protected by Section 35 arise from that prior occupation. The court also determined that there was no additional requirement for recognition by a related Aboriginal collective in Canada. So if this threshold question is met of, are you an Aboriginal people of Canada, you then move on to the standard Vanderpeet analysis, which is a test used for groups within Canada for determining Aboriginal rights. And so because Mr. Desoto is a member of the Lakes Tribe, which is a modern successor of the Saikus, and his claim satisfied the Vanderpeet test, the relevant sections of the Wildlife Act were of no further effect with respect to him. And in response to practical concerns raised regarding the extension of Section 35 to groups outside of Canada, the majority of the court stated that while Aboriginal communities outside of Canada can assert and hold Section 35 rights, it does not follow that their rights are the same as those of communities within Canada. While the test for Aboriginal rights is the same, the different circumstances of the communities may lead to different results. And so it is a fact-based analysis. Next slide, please. Additionally, it's worth noting that the Crown may have a duty to consult, which arises where it is actual or constructive knowledge of an asserted Aboriginal right that may be affected by Crown conduct. Recognizing that the Crown is less likely to have this sort of knowledge when groups are located outside of Canada, the Crown is not required to go and seek out groups that may potentially have Aboriginal rights in Canada. Instead, the onus is on the groups asserting those rights to put the Crown on notice of these claims. However, once the Crown does have notice, the duty to consult will be engaged. So this case is of more importance, obviously, for proponents where they have projects that are closer to the border region of Canada, but it is something to be aware of generally. So that is kind of the four recent cases that I thought would be of most interest today. There's a lot more that we could talk about, but that was the focus in order to get us through to the panel discussion, which will be have some great insight. So I'll pass it back to Kai.
Thank you so much, Dani. That was really useful and very insightful. Helps us to understand the larger issues. And just for the audience, if you have specific questions, I know we've received one question specifically about some of this case these case laws. We'll be bringing Dani back in for the question period, so please provide your questions in the place for questions, and it will come to us, and we can address your questions during on the case law in the question period at the end. Thanks again, Dani, and I'd like to welcome Emilie, Sophie, and Zach to join me as we go through some of the broader trends. When I was introducing, I mentioned all of this case law is very consequential and important, but we're also seeing important trends both in permitting and legislative change, as well as changes in how First Nations are negotiating agreements. So we really wanted to broaden the scope out a little bit and talk about trends outside of the courtroom. One of the main trends that I think all of us have been seeing, but Emilie, I'll ask you to comment on first, is that over the past few years, there's really been an increased role for Indigenous communities in environmental assessment processes in Canada. And so I'd like to start there. And Emilie, if you can just walk us through sort of why is this happening? Where is it? What's the basis for it? And how do you expect it to evolve going forward?
Thanks for the question. I think it's a very interesting one, and I think there are many factors that come into play, including there's definitely a global trend, not just in Canada, but a global trend about more recognition for Indigenous peoples around the world. So that's certainly part of the reasons or the factors for that trend. There's also greater access to information today for First Nations and Indigenous groups about their rights than there was before. Think about social media or any other types of access to information for them. Think about bigger events that occurred in Canada. That was before COVID. So the blockades in early 2020, I think that brought a lot of attention around Indigenous groups' activism across the country. So that's also part of the factors, I think, that we see Indigenous groups engaging more in environmental assessments that maybe they used to some years ago. There's also, I think, a big legislative change that probably pushed that, let's say, a little faster, and that is the entry into force of the new Federal Impact Assessment Act in August 2019. There's an overarching theme in that act that's about Indigenous peoples and that calls on ensuring their rights, culture, and traditional knowledge is considered at various stages of the process. So it's clear from the purpose of the Act that there has to be more Indigenous groups' engagement in the environmental assessment process. And although that's not novel in itself, because it in a sense, it reflects case law and the duty to consult and where we are in the development of the law, but there's definitely more formalization of the participation of Indigenous groups in the regulatory process at the federal level. And that's also translating into other provinces. But there's so for proponents who, let's say, have been working and engaging proactively with Indigenous people in consultation activities from very early in the process for a number of years, that's not going to be so different. It's going to make their actions more visible. But for certain Indigenous groups, it's definitely going to facilitate their participation in the assessment process. So we're going to see more, I think, of that coming. And I'll let Zach and Sophie speak to how the trend translates into their respective provinces. But in Quebec, we certainly see this trend playing out. And it's not only in major project approval, like the BAP or the COMEX, but it's also in regulatory permitting process. And that's particularly novel for Quebec, that we see more and more engagement from Indigenous groups in the process. And you can think about exploration activities, advanced exploration activities, logging permits. We didn't, so we used to see less Indigenous groups engaging in those types of permitting process than we see today. And so since there's no regulated consultation process for those regular permits in Quebec, it makes things a little bit more difficult for proponents until I think the framework or the government can establish a framework that's more adjusted to that type of consultation. But it's not because it's not regulated that it doesn't apply. There's still a duty to consult, still applies in Quebec like it applies in other jurisdictions. But there's a lack of framework that makes it sometimes difficult for proponents. And so, but we're seeing more and more interest of Indigenous groups and more groups proactively reaching out to the regulators. And so that can result in delays and whatnot to obtain the permits. And so whoever wants to avoid or mitigate those risks should definitely, proactively engage at an early stage. And that way you tend to have more success on the long term. And I don't know, Zach, maybe you want to speak on your area, your region to that.
Yes, thanks, Emilie. Entirely consistent with the changes we're seeing to the federal environmental assessment law. In BC, we're seeing under the Environmental Assessment Act, consensus-based processes of the EAO, or our provincial EA regulator, emphasizing Indigenous consent. And see processes which ultimately seek to operationalize the regulatory jurisdiction of Indigenous nations as decision makers in the EA process. Now, under our provincial legislation, the Act requires consensus to be sought from participating Indigenous nations before a number of key points throughout the EA process. This includes before the setting of procedural requirements for the EA, including the time limits for how long the process will take, recommendations about whether the EAC, the key environmental approval under our EA legislation, should be issued at all, and amending decisions about whether to amend or not an existing environmental assessment certificate. On the consent side, we've seen with recent changes to our Act under the Environmental Assessment Act, codification of two key opportunities for Indigenous nations to indicate whether they consent or not to a proposed decision by the EAO, including, and this is whether to exempt a project from the EA or terminate the EA process for a project, as well as whether the EAC, again, the key environmental approval, should be issued at all. Now, in addition to this, we're seeing, in addition to these consensus-seeking and consent-seeking processes, the Act also contemplating that a participating Indigenous nation may lead all or a portion of the assessment of the effects on the nation and its rights, requires some agreement and substantive discussion with the regulator on how that works, and we're still figuring out how that plays out on the ground. But in some, consensus-seeking, consent-seeking, and expanded roles for Indigenous governing bodies as potentially regulators in the process. And Sophie, maybe I'll hand it over to you to give us a sense of what you're seeing in Ontario.
Thanks, Zach. So at the EA level, we haven't seen similar things happening at the legislative sort of level, but I will speak to one key example that is playing out in Ontario, and that is what is happening right now in the Ring of Fire region. So there have been strong calls in the past few years by certain First Nations for an increased role in the regional assessment that is proposed for development in that region, which is being conducted under the new Impact Assessment Act that Emilie spoke to. So last April, 3 First Nations jointly issued a moratorium against any development in and access to the Ring of Fire region in Northern Ontario. And this moratorium strongly called on both levels of government to agree to a regional assessment that would be led by an Indigenous governing body provided for under the IAA. And just a few months ago in January, during the open comment period for the proposed terms of reference that were issued by Canada and Ontario, a group of First Nations issued a letter again calling for a First Nations-led RA in the area and requested that the terms of reference actually be redrafted with Indigenous participation and leadership. The draft terms of reference as prepared by both levels of government did include opportunities for participation by Indigenous nations and other interested stakeholders. But what is being requested here by these First Nations are equal partnership in their development and the implementation and enforcement. So we'll have to watch and see how these developments play out. But as indicated by my colleagues, I expect pressures for an increased role for Indigenous communities to continue.
Thanks a lot, all of you, and thanks, Sophie. I'm gonna stay with you, Sophie, for our next topic. It's sort of funny, you know, I've been observing that like 2 or 3 years ago, everyone was talking about Undrip and free, prior, and informed consent. It was like you just couldn't go to a conference without there being 5 different webinars or seminars on it. But now people are talking less about it, but it's actually getting translated into law. So I'm just wondering if you could help our audience members sort of just calibrate on what's happening now. Give us the tour. What's happening now? How is Undrip entering into Canadian law?
Sure. Thanks, Kai. And it's a great question. And it's certainly a big topic. I think you can spend an hour at least speaking on both. But I'll start us off with Undrip. As we all know, it stands for the UN Declaration on the Rights of Indigenous Peoples, which was adopted by the UN General Assembly back in 2007. So it has been around at the international level for some time. Canada did not officially endorse Undrip until 2016, though. At a very high level, it is a non-binding international human rights instrument that sets out certain collective and individual rights for the survival, dignity, and well-being of Indigenous peoples globally. It's important to note that declarations like Undrip are not meant to be brought directly into domestic law. Rather, their role is more to inform the interpretation of laws and to inspire a legislative change. So, Kai, as you asked, where does that leave us in Canada and where are we at here domestically? So 2 jurisdictions so far, BC at the provincial level and Canada at the federal level, have passed legislation that provide for a framework to implement Undrip within their respective jurisdictions. So BC's DRIPA became law in November of 2019. And at the federal level, we have Undripa, which became law this past June in 2021. So to be clear, these acts do not give Undrip, the declaration, legal effect in Canada in and of themselves. Rather, they do 2 things. So first, they affirm Undrip as a universal international human rights instrument with application in Canadian law. And second, they provide a commitment by both levels of government to take all measures necessary to ensure that their laws are consistent with Undrip. And this refers to both existing and current laws, as well as future laws yet to be made. And this work is to be done in consultation with Indigenous peoples in Canada. So it's important to understand as well that the Act will uphold Aboriginal and treaty rights that are already protected by Section 35 of the Constitution. It will not lessen them in any way. So going forward, this Act requires that both levels of government develop an action plan, as well as deliver annual reports on progress made. So in short, Kai, on this, the hard work still remains to be done regarding Undrip in Canada. And I've heard a reference that this work will be generational work. I think for those in the mining industry, the legislation doesn't create any new obligations or regulatory requirements, at least not yet. Industry will continue to be required to meet its procedural requirements as set out in existing laws, such as the Impact Assessment Act and so on. So moving on to FPIC. So there are a number of international conventions out there that reference a government's obligation to obtain free, prior, and informed consent of Indigenous peoples before making decisions or taking actions that may affect their communities. And there are various articles in Undrip that do just this. Now, how FPIC is defined and interpreted is a matter of ongoing debate. These conventions are often cited by Indigenous nations and communities and other groups as well as confirming that they will be afforded an opportunity to grant or deny their FPIC. So in effect, having a veto power in relation to activities that may adversely affect their rights. It is framed differently by others who would suggest that a closer reading of Undrip shows that in most instances where FPIC is referenced, the obligation is really on consultation with the aim of achieving consent. The focus of FPIC then in this definition is more on the process of consultation rather than the outcome. And one definition or way of framing it that I have found helpful was provided by one UN agency. And they've done a breakdown of each of the terms. So when we look at free, what this really means is that there is no manipulation or coercion of Indigenous peoples and that the process is self-directed by them. When we look to the term prior, we mean that consent is sought well in advance of any activities being started or authorized, and that there is sufficient time for the consultation process to occur. And informed requires that the relevant Indigenous group receives enough information on the key points of the project. And that, of course, this information is provided in a language that is well understood by the reader. I think a closer reading of Undrip does point to a distinction between when FPIC is required and when it should be sought. So FPIC is required where the impacts to Indigenous lands are considered significant and permanent, but is only required to be sought where undertakings have the potential to impact their lands. And this would imply that a failure to obtain consent would not necessarily be a bar to government action in the latter case. And I think this interpretation is generally consistent with the consultation framework that exists currently in Canada under Section 35. So in practice, conflicting interpretations of FPIC may present a challenge for industry in various ways, but in particular, in an instance where consent by an affected Indigenous group is not obtained, but an approval is granted. A decision as to whether or not to proceed with a project would require a holistic review of all the facts. But notwithstanding differing interpretations of FPIC at a minimum, I think that FPIC will influence current approaches to consultation, and that consultation processes may become more robust for some. Both the Crown and industry, when they are exercising their procedural requirements, may become more proactive to ensure that those standards of free, prior, and informed are met. And I think in many ways, industry is already doing a lot of this work and is doing it well and working on building healthy relationships with Indigenous partners to build sustainable and long-lasting projects. And I think Undrip and FPIC only strengthen the case for industry to continue on with this work and these efforts. So with all that said, I'll pass it on to Zach and Emilie, and perhaps you guys can give us a bit of an update on Undrip or to elaborate a bit more on their impacts in BC and Quebec. Maybe Zach, do you want to go first?
Sure. Thanks, Sophie. And as Sophie said, BC back in late 2019 brought in what we're calling DRIPA as a means of implementing Undrip in BC law. Important to note that Section 7 of BC's DRIPA empowers the government to enter into decision-making agreements with Indigenous governing bodies, which provide potentially for joint decision-making or potentially imposing a requirement for Indigenous consent in relation to statutory decisions of the provincial government. So these negotiations require a mandate from government in accordance with the process set in DRIPA. We saw the first such agreement. The negotiations for that agreement started in 2021 in June, when the provincial government had announced that it began a consent-based decision-making agreement negotiation under DRIPA with the Tahltan Nation. This agreement, the province says, is focused on environmental assessment approvals for 2 projects in Tahltan territory: the restart of the past producing Escape Creek mine and an expansion of the Red Chris mine in northwestern BC. And we understand at this stage negotiations are still ongoing. And while it's still early days, in terms of how this will play out on the ground, in terms of DRIPA implementation, the province has been clear repeatedly that DRIPA will not affect how decisions are going to be made at an operational level in the near term, both in the summaries that they produced in writing and in answer to questioning on the floor of the legislature and in the legislative committee prior to the enactment of the legislation. However, expectations from Indigenous nations are that DRIPA is a historic step and that it recognizes a right to free, prior, and informed consent. In addition, and this is no mystery to project developers across Canada, nations see consent in many cases as a condition of project approval. So, in sum, this is going to put pressure, I think, on projects in BC to assess whether express consent is going to be or is already necessary for regulatory purposes, even before a nation concludes a bilateral Section 7 DRIPA agreement with the province. And then that, maybe, Emilie, if I could turn it over to you for a view on what you're seeing in Quebec.
Yeah, sure. Thanks, Sophie and Zach. So unlike in BC or federal, there is no legal framework incorporating Undrip or FPIC into Quebec law. So we're not there yet in terms of our legal framework, but it doesn't mean that the concepts have no application in Quebec. So what we've seen recently is the Ministry of Energy and Natural Resources publish its Aboriginal community consultation policy specific to the mining sector, which sets out specific guidelines and also general principles around consultation. The policy is actually derived from an obligation that the minister has under the Mining Act. It took a while for the minister to publish the policy, but now it's been around for a couple of years now. But the principles, in a way, echo some of the principles under Undrip and FPIC. And so the first one is for proponents to initiate the consultation process as soon as possible and to maintain a dialogue with Indigenous communities during each stage of the process of the project, and that includes exploration activities as well as production. For the minister, it's to provide an opportunity for Indigenous communities to express their concerns prior to the issuance of the permit, and so those free, prior, and informed principles kind of resonate into the policy. And obviously the concerns that are expressed by the Indigenous communities may have an impact on the requirements that the minister will set in the permit ultimately granted. And the policy even states that it's even possible for the ministry to occasionally refuse or deny granting the permit or the authorization that is sought by the proponent. So those are words that we did not we're not used to seeing in government policies in Quebec, but now it's there. So that's the way I would say that's closest to an implementation of the principle the principles of Undrip and FPIC, and other than that, for now, we're not seeing anything formal in Quebec.
Thanks, Emilie, and thanks all for the summaries and perspectives. I want to move on to our next topic, and to set it up, I think so far we've been talking about litigation, really legislative change, permitting, international instruments even. All of those are the visible parts of Aboriginal law. It's the kind of the tip of the iceberg, so to speak. But as all of our panelists are very much involved with negotiations between project and proponents and Indigenous communities, I thought it was also worth raising the topic of sort of trends in agreements, trends in that kind of below the waterline conversations that happen between companies and Indigenous groups. Zach, can you kick us off in terms of how proponents are negotiating agreements to safeguard project certainty and share project benefits, and what trends you're seeing there?
Yes, thanks very much for the question, Kai. And it's obviously an important one that we're all, as you say, all dealing with every day. Building on what we've heard so far from my colleagues, they've made clear, I think, that, the provincial and federal EA processes emphasizing consensus seeking and consent, the recent decisions Dani outlined, including Ermineskin, and earlier decisions like Sophie, and the Undrip-based legislation, that we discussed earlier as well, are all driving consent-seeking agreements on behalf of both Indigenous nations and proponents. Now, in the context of project-specific impact benefit agreements, or IBAs, there's some key trends to watch out for that we're seeing. The first is that Indigenous nations are increasingly reluctant to provide consent at a time when, as we've said, the legislation and the regulators are placing increased emphasis on consent and consent seeking. Now, this places pressure on proponents to find a path forward that enables a nation to provide that consent to a project at the appropriate time. And from a proponent perspective, this really requires careful, deliberate planning and strategy to address, among other things, the process required to achieve and also sustain that consent over the life of a project. The information an Indigenous government is going to require to demonstrate that they've discharged their obligations, including in relation to stewardship and environmental management, to their territory, as well as their obligations to their members, and including also the authority that is required from a nation, and to evidence that, in fact, the consent that's been provided in an agreement is, as Sophie described, free, prior, and informed. Second trend we're seeing is, IBAs are increasingly becoming complex commercial arrangements. There's been a steady shift in the market from reliance by Indigenous nations on litigation counsel to commercial lawyers. And as a result of that, commercial terms are being heavily negotiated and are increasingly tailored to meet specific commercial circumstances. This is particularly the case, for example, with respect to financial terms. And there are a couple of key trends we're seeing. The parties that we're dealing with are deliberately structuring financial terms to reach a financial objective and attempt to minimize variations, both up and down. Parties are also agreeing to mechanisms which allow projects or an Indigenous nation to adjust the mix of benefits that might be available during the term of an agreement. And that could be, for instance, cash in lieu of an investment opportunity or shares in lieu of a royalty payment. And lastly, on IBAs, there's a steadily increasing interest among many Indigenous nations in equity ownership. Now, equity ownership opportunities are coming up most typically in two situations. An IBA, at the front end of a project where you're looking to incentivize consent and support for the project and its approvals. in exchange for material economic benefits. And then alternatively, in the context of M&A transactions, where you're looking to increase sale price, deal value, but also mitigate risk to your sale process. Now, a key advantage of equity is that it aligns the interests of the business and Indigenous nations, since equity participants are going to be interested in helping to contribute to changes or investments that will increase their earnings. But it's also important to remember that equity participation is considered to be of high value, and that does add potential business complications. So it's typically reserved for high strength of claim situations. And lastly, in addition to project-specific IBAs, where we have at its core a trade, consent support in exchange for project-related benefits and commitments, recent changes that I've outlined to BC's EA regime, in which Emilie outlined in relation to the federal law that applies in BC, and again, specifically the emphasis on consensus seeking, consent, and the increasing role of Indigenous nations as assessors and potential regulators in relation to projects and in relation to the EA process, are leading proponents to conclude agreements that guide the regulatory process for these potential Indigenous-led assessments. Now, this is a trend that will continue to grow in BC, we think, as more nations revive their legal orders and seek to apply their legal orders, both as regulators and as governments in relation to major projects. With that, maybe Sophie, if I could get your view on what you're seeing in Ontario.
Yeah, that was a very helpful summary, Zach. I don't have much to add in terms of specific provisions and all that. I think you really covered the basis there. As you know, IBAs are evolving rapidly and are becoming increasingly complex agreements. I think parties just need to stay open to coming up with creative solutions with Indigenous partners and nations affected by their projects. What I will add, though, is interestingly in Ontario, the Ministry of Northern Development and Mines recently published a statement for the first time on community proponent agreements. This was published in December. That may be of interest to some viewers. The statement sets out to emphasize the role in consultation that is legally required to be carried out by the Crown, but which has procedural aspects delegated to proponents as compared to community proponent agreements like IBAs, which are negotiated more as an industry best practice for relationship building and for obtaining social license to operate. I find the statement did help provide a helpful reminder of the different roles that government and industry plays in consultation. The ministry also posted an updated consultation framework, similar, I think, that Emilie was mentioning you have in Quebec, in terms of a guidance document for how to navigate the Mining Act and various requirements for consultation with Indigenous communities at different levels, at exploration to advanced production. So do have a look at those two documents for guidance in Ontario. And Emilie, I'll pass it on to you.
Thanks to both of you. So as I mentioned earlier in the panel discussion, we've seen an increase in mobilization of Indigenous groups, at least here in Quebec, and I know it's true across Canada, even by those groups who historically had not been much involved in project-related matters. And what that means is we see a lot of Indigenous groups reaching out to proponents of existing mining projects. So not only proponents of new projects or projects that are being proposed for an EA process, for example, but brownfield projects, active or operating mines. And so that negotiation can be very different from a greenfield project. So I think everyone should be mindful of that trend as well. And so that has translated into some of the projects being either delayed or stopped momentarily or for some time for lack of social license to operate. And so proponents now have a clear incentive to proactively engage with Indigenous groups, use comprehensive agreements to secure consent, support, certainty for the project, and reduce the likelihood of legal actions on the basis of inadequate consultation, but also, and I think probably more importantly for proponents, to mitigate the risks of having project delays or others. And so one thing that we see in agreements that we saw less in the past is ongoing consultation process built in the agreement to re-secure that consent and that support throughout the life of mine. So those are aspects, I think, that are worth mentioning.
Yeah, thank you, Emilie. I definitely agree, and I've seen that trend towards brownfield IBAs as well in my own practice. Well, that's been fabulous. Thank you all very much for the for your thoughts on those key trends. We've left plenty of time as intended for questions, and one of the best things about holding these kind of webinars is our participants are so smart and intelligent and ask such great questions. So we've already got some good ones. I would encourage people to keep them coming, and maybe we can advance the slide and make sure Dani is brought back in to assist in answering some of these questions. And I think we'll start with Dani, actually, because there was a specific question that came up in respect of the Yahi decision. And the question relates to how broadly the decision is interpreted with respect to other Treaty 8 signatories. And does it differentiate between areas where a nation makes intensive use and other areas? Maybe I can ask you just to clarify that one point.
Yeah, for sure. That's actually a great question. So the Yahi decision specifically addresses Blueberry River First Nations rights and impacts to those rights. It is not applicable to any other nations. There are lots of nations with overlapping territories, so you may be able to maybe assume certain things, but the strict legal implications are for Blueberry River First Nations. And for the area claimed, which was a portion of their traditional territory. That doesn't mean that that's the end of the story, though. The province has stated that they are in discussions with Treaty 8 nations about specifically to advance restoration efforts in the area. And as well, they're in discussions with them about the negotiations they're having about new regulatory processes for addressing project approvals in the area. So while the specific decision is specific to an assessment of Blueberry River First Nations preferred areas to exercise their rights and the impacts on those the exercise of those rights, other Treaty 8 nations are being involved in the process moving forward.
Thank you. Thanks a lot, Dani. And another question that came up has to do with a particular permitting process in Quebec, a kind of a one-stop shop permitting process that you have. Emilie, I wonder if you can comment on it. The question relates to since the process is intended to bring all the parties around the table, the question is around why doesn't it add a layer of legal counsel validation to make sure everything's covered? But I wonder whether, because I'm sure that many people in the audience aren't familiar with this kind of open house process, whether you could just describe it quickly and then address the question about legal counsel involvement validating that the issues are covered.
Sure. I'll do that. So what we call the BAP process is actually the public hearing part of the environmental assessment. So our provincial environmental assessment here in Quebec. So in parallel to the BAP, which is the public hearing and open house, it's not a legalese process. It's really for the members of the public. So they're Indigenous groups, yes, but also environmental groups, NGOs, the general public who can participate. And it's basically a board who's listening to concerns and comments from those stakeholders. So that's one part or one component of the environmental assessment process. Now, the question, if I'm reading it correctly, suggests that there may be a lack of legal validation as to whether everything is covered before the BAP reports to the government for recommendation on a specific permit application. And so what the BAP does is they issue a recommendation as to whether or not the government should approve the project. But at the end of the process, the government can take any decision. So they're not bound by the recommendations of the BAP. And very often you'll see consultation by the government itself, so separate from the public hearing. So the government, as the Crown, the provincial Crown, will run its own consultation process with the Indigenous stakeholders that they have identified as having standing, if you want, for consultation, or as having the status for the Crown to discharge its duty to consult. So those are two separate processes. But it's true, there's no validation within the BAP itself. It's a separate exercise that's done by the Crown as part of the process before the government decides to issue or not the authorization.
Okay, great. Thanks a lot. I hope that's helpful. We have another question, which is usefully split into two parts. So I'm going to ask Zach and Sophie to each take one half of the question. The question starts with how, and I think, again, really sharp question, how do we know when a nation has given its consent to a project, permit, or activity? So all very well to talk about free, prior, and informed consent, but what does consent look like? And there are two aspects, so two specific questions. The first question is, what if the consent is given to the proponent, but not in respect of the Crown? And the second one is, what happens if the nation gives consent, but then individuals, members of the nation, family groupings object to the project? And so maybe I'll give Zach, if you want the second one, say so, but I'm going to start you off on the first one, and then maybe you can say a few comments about what consent looks like, and then address that consent to the project versus consent to the Crown question. And then Sophie, will turn to you again if you have any general comments on what consent looks like, but if you can tackle the member question, how do we know and how do we protect against nations consenting, but then members acting independently? So we'll start with you, Zach.
Thanks, Kai, and thanks for that great question. So at its core, and at the end of the day, this is why agreements are so important. So, as a self-interested solicitor, when we're talking about consent, ideally you're dealing with an IBA which provides a piece of paper, some evidence to demonstrate that the properly authorized representative of the Aboriginal collective you've been negotiating with has expressly consented to the project, that you've submitted the description for to the regulator, and that is hopefully approved by that regulator at some future point. What that looks like can vary from agreement to agreement, but at its core, it says, we nation, the properly authorized representatives of that nation, consent on this piece of paper. And when the company requires it, the company can share a copy of that paper with the regulator to demonstrate that consent has been provided and that it exists at the point in time it matters for the company. If it's not yet been given to the Crown, this really is an agreement matter. It's making sure that your agreement says that the company has that consent it can provide to demonstrate to the Crown that it can rely on that consent and that agreement to authorize the project based on the consent you're holding. So really it comes down to drafting, but ultimately making sure it's evidencing a properly authorized representative on behalf of the collective has consented appropriately.
Right, and that it extends to the Crown, because often these duties rest with the Crown, and so just promising the proponent and holding back on the Crown may be problematic. But you're absolutely right. It's in the IBA. It's on the piece of paper, and so that's why well-drafted agreements are the way to go. Sophie, this comes up all the time in terms of members taking action or subgroups or hereditary chiefs within a nation. Do you have any comments on how to deal with this sort of members question?
Sure, Kai. I mean, I think industry and the country after the Wet'suwet'en conflict, I think is increasingly cognizant that Indigenous communities will have their own decision-making processes, and that will vary from community to community. And just like in, at the federal level or in Canada, sometimes some members may not agree with what is being sort of agree to at the leadership level. In some communities you have elected chief and council, whereas in others you will have a hereditary leadership that works with chief and council and so on. And again, going back to the Wet'suwet'en conflict, where we had the Wet'suwet'en First Nation hereditary chiefs opposing a natural gas pipeline in their traditional territories, and that position was different than that being taken by elected chief and council. This made headlines across the country, and just was not a good situation for the company and the project overall. I think some right from the beginning, what we need to be doing is doing proper due diligence in ways of how the nation governs itself, and to ensure that you have all proper voices at the table, to ensure that there are substantive and meaningful meetings of the community where all voices are being heard. And as Zach mentioned, ensuring that gets reflected in your agreements. Zach, I know that you've been working on an agreement where you are sort of addressing and accounting for hereditary leadership. Maybe you can actually speak to how that's being reflected in agreements. But I think focusing again on the contract between the community and the company is where you end up at the end of the day.
Thanks, Sophie. Yes. In quick terms, really what we've attempted to do in our situation is be clear early on in the process about how that interplay between the hereditary leadership and the elected band council of the First Nation interact. Who are the deciders? What is the process? When do decisions need to be evidenced clearly? At what point in that process can we share that evidence and that decision with the regulator? But at the end of the day, it comes down to being, and in our case, has involved being very open and be very clear at the outset to make sure that we've essentially asked questions to understand that process in the spirit of fostering, transparency, trust, predictability in that relationship, listening, making sure you're not making assumptions on the basis of what another community does, and then seeking an agreement to formalize what these mutual understandings actually look like and how these processes will work. But ultimately, that's been our takeaway in our main process and the agreements we're working on in BC.
Emilie, did you have something you wanted to add there?
Well, maybe just something about support clauses that you can add into your IBAs. So when you'll get into that section around consent and support, you'll want to have a clause that can actually cover those types of situations where you'll ask the your counterpart to actually defend the IBA and defend the consent that's provided by the community in any event, in the event that there's either a third party, another First Nation, or some members of the First Nations that are not complying with the agreement, basically by opposing the project, for example.
Yeah, thank you very much. I'm gonna bring in, because in advance some people submitted questions in advance, so I'm gonna bring up one of the questions we received in advance. I'm not sure if the person who asked the question is on the line now, but I'm just gonna sort of combine that with another question, because we're coming up on to the end. I want to just make sure as many questions get answered as possible. So the question we received in advance was around, and I'll expand a little bit. We've been talking a lot about FPIC and Undrip and regulatory changes. What should companies, so what's the sort of practical advice? What should companies be doing to ensure that their consultation processes are high quality and that they can increase the likelihood of obtaining consent from First Nations or obtaining project approvals? I'm going to start with you, Dani, but I want your view as well, Emilie. And at the same time, here's the double duty. Remember the second question. We got a question earlier just asking, before we even really got into the presentation, about what's different in the Quebec situation versus the rest of Canada. We've talked a lot about that, but I just wanted to make sure if you had any thoughts at the end just to close us out after you've answered the question on consultation, if you could just comment on that. But we'll start with you, Dani. Practical advice on how in this terrain do companies manage their consultation processes for best effect?
Sure, it's a great question, Kai. The typical answer, the answer you hear all the time is early and often, right? And that's true, but that really doesn't help that much. What does that mean? How do you do that, and why? And I think that's something that's missing from the early and often answer is the concept of, with an aim to actually address the First Nations concerns, right? The whole point of consultation is that your goal is to figure out a way to address their concerns. And so, yes, starting consultation early, having the right people at the table is really important. There will be times where it will be appropriate to have senior leadership at the table. It may be when you're starting a relationship, if you don't have a relationship with a nation yet, you may want to have senior leadership there to meet with the chief to get the process started, to start to build trust. There also may be situations where throughout the process, there's difficulties that develop in the relationship where you're not able to do something that the nation is hoping that you can do, or some sort of conflict arises where you again might need to bring in senior leadership to show your commitment to being at the table. As well, having the right people at the table also means having the people with the right expertise to address those concerns. So in some instances, that could be, having the proper, environmental folks or engineers to explain and work through whatever the issues are, again, specifically to try to address those concerns. And the early piece also is important because, as Zach and Emilie mentioned earlier, the legislation regarding reviewing projects has shifted, and there's more of an emphasis put on early engagement, and the earlier you do the engagement, the earlier you figure out what those issues are, and you can start working on trying to address them to hopefully avoid project delays. So that's all important. And also with those changes in the environmental assessment process, really understanding what Indigenous groups' concerns are, what their interests are in the project, and trying to figure out ways to work with them on that is really key. If you can find a way where, there's a specific interest, like, fishing or fish that needs to be addressed, and you can find a way to work with them on what the proper way to assess that is, and consider mitigations and all that type of thing, that's really going to get you ahead of the game. If you can start thinking about those issues early and try and work together on some of those issues. Emilie?
Thanks, Dani. I think I would continue on with, in addition to early, make sure it's adequately funded. So you need to dedicate the resources to the process. And so, the easiest way, or I would say the smartest way, is to have that into a capacity funding agreement that provides for a consultation process that you would implement way in advance. So very often I feel like some proponents are afraid of sharing information at an early stage, thinking, we're not ready. We're not sure exactly how the project what the project will look like, but that's exactly when you need to engage. So start early, offer some funding for the Indigenous group to actually assess the material, share their comments, make sure it's structured. That will definitely help in terms of going through the consultation process. Take minutes of all of your meetings, including telephone, teleconference and video conference and whatnot, and take them verbatim. Like, just don't rephrase what everyone has been saying. Just take the verbatim of the minutes, very neutral, stating who said what. That will get you a very comprehensive record of the concerns that were expressed. And you can then consider sharing them with the Indigenous group you're consulting with. And if they provide comments on how you took the minutes, you can just attribute those edits or those comments to them if you disagree with them. But it's usually not worth fighting the content of the minutes that much. And of course, don't mix consultation and negotiation. That should be kept separate. In terms of would we do this differently in Quebec than elsewhere, the answer is no. I think best practices for consultation and negotiation of agreements are the same basically across the country. And so early engagement, often like regular meetings, being open, don't be afraid to share information, log your communications. Those are principles that I think apply across the board.
Yeah.
One thing I just wanted to add. Oh, sorry, Kai. One thing I just wanted to add is to benefit your consultation process. It often benefits to have a parallel negotiation process at the same time. So if it is a nation that you're interested in entering into an agreement with, then don't wait to start those negotiations, because going to the table there shows your interest in working with the nation and helps build trust, I think, across the board.
Yeah, the only thing I would maybe add to both of those excellent answers, and it's sort of implicit in those answers, is really be thoughtful and strategic and purposeful in designing your consultation process. Sometimes I think we see standard operating procedures emerge, or people just doing the same thing that they did last time, or feeling like they have to do X. But maybe take a step back, talk to legal advice or your consultants, try to understand what you're trying to achieve, and then work backwards from there. Because sometimes you can say, well, I'm consulting, but I have a very strict project plan, so I can only give the First Nations a week to reply. Well, you're probably actually making things worse by doing that. Maybe taking a step back, saying, okay, what's the overall thing that we're trying to achieve? And then design around that. Listen, this has been wonderful. We have many questions which we weren't able to get to, and I know I am speaking for all of the panelists that we are available, and just this is the stuff we love. We love this stuff. So if anyone has any questions, please don't hesitate to reach out to us. And I'd like to thank Emilie, Zach, Sophie, and Dani for just a wonderful presentation, and thank you all for joining us today. We could keep going, but we need to close. Now, look, I know all of you are going to be just jittery for this high quality legal content. And so I am asked to tell you that the next session will be Future of Work, taking place March 8th, beginning at 8 a.m. And you can sign up for that webinar or any of our upcoming webinars at the Fasken Institute section of fasken.com. We hope you can join us then and again. Thank you all very much.